break my argument down into 4 parts for the court, but before I do, I must say what part of this case is not in dispute. That is that Ms. Holly Bobo and her parents and friends and family are the people who make West Tennessee a special place. The horror of April 13th, 2011 remains an unmitigated tragedy, and nothing I say diminishes that. An outrage that this crime took place is not relevant in these proceedings. The 4 parts to my argument are the story of this case. I'm going to address constitutional violations. I'm going to address the proceedings themselves, these post-conviction proceedings themselves, and end discussing the obligation that the court has. Before I get too technical in the legal arguments, I'd like to just summarize this case. April 13th, 2011, a beautiful young nursing student was taken from her home, traveled in a clockwise manner until her cell phone stopped traveling for 30 minutes. This is where U.S. Marshal tracking expert suggests she was killed. No evidence before that was found along a route. A bullet consistent with a defect in her skull was found next to her remains. Evidence was thrown out for personal belongings from that location along the route that ended at Gooch Road. Most of her personal belongings were found next to her remains. I will not belabor the evidence that made law enforcement and General McAdams submit there was probable cause that Terry Britt committed this crime. Britt had a search warrant served on him and installed, while he was briefly incarcerated, various wiretapping and bugging devices. Soon after he returned, he was told they probably are bugging you. Nothing happened. 2011 turned into 2012, turned into 2013. This case was becoming a cold case. Terry Britt told Marshal Walker to get an agreement giving him certain prison time. He just wanted his wife Janet kept out of it. He was not Mirandized. He took 15 years on old charges that Janet Britt was let out. By the way, if he had been serving for that crime that happened in Madison County, he would have been incarcerated on April 13th, 2011. In the words of Brent Booth, this case is haunting. As time developed, TBI blamed the Bobo family. The Bobo family blamed TBI. Nobody could blame them. What follows that began in late 2013 can only be explained by understanding the juxtaposition of impenetrable truth that scientific data provides and the manipulative propensity of what people say. And these people who are either scared, want reward money, or have their memory replaced with inferences and impressions to regurgitate or, quote, nail down. Enter Dennis Benjamin. He begins working with TBI head agent Jack Van Hoosier, retired cop, becomes the go-between between the Bobo family and TBI. His job was to get some arrest. Enter Sheila Kilser. Her son was arrested with Jason Kilser. Put aside that both Sheila and Jason had already denied knowledge or involvement. Sheila and Jason get law enforcement to believe Dylan knows more. TBI pounces. Even though what Sheila heard was false, TBI begins the belief that continues throughout that they have the omnipotent superpower to know what the truth is. And thus anything that points to arrest is true enough to further their aim. This is a central theme of everything you've heard. Dylan is pressured from jail. He gets a sweetheart deal, the contents of which are under seal. I will not discuss that. I would just ask the court to read it. A word about Dennis Benjamin. He had been told in February of 2014 by Victor Densmore that Dylan was the weak link. In March of 2014, Benjamin is back in Indiana telling Densmore that he's going to get the death penalty if he doesn't tell him where the body is. In dismissing Benjamin, Densmore says, "I'm not even interested in the reward money." We are to believe that a drug addict's statement to his girlfriends, his drug buddies, and other jail inmates are gospel. All are statements that were provided or not provided or misconstrued to the most vulnerable of our citizens. They were worried about arrest, losing custody, reward money, and thus everything the state has mustered in an ambush of these people, or to put it into their words, run to the ground. Persist until they say enough to implicate these four, even if it's inconsistent, even if it's demonstrably false. It doesn't matter. I could not summarize this part of the case better than Agent Joe Walker did on page 483. There were a lot of statements that ended up not being true. Now it's time to find the credible points of data that corroborate this scientific data that cannot be manipulated. None exist. Every single part of their life was searched for DNA evidence. None. Fingerprints. None. A gun that could have been used in the crime. None. Nothing. Not the palm print at the Bobo house. Not the crop print. Not a single thing. They have that a meth addict scratched his arm. Dylan's statement is thoroughly rebutted by the cell phone records. It's no wonder why within weeks of Jason Autry's story being released, his attorney wanted the cell records just one more time. Instead of saying Dylan's story was not true, the state has tried more creative avenues by saying it was too self-serving. After he made the statement, he was politely escorted to jail where he has been ever since. Fugitive tracking experts placed the location of death where the remains were found. He was needed to be an expert when the state was trying to solve this crime. You heard from Agent Frizzell today. When his opinion did not fit within the strictures of the manipulated testimony, he was discredited. Could not show it any better today. Agent Frizzell and I recreated Marshall Walker's map. The foundation of my entire trial has been trying to explain April 13th, 2011, and when I finally had Agent Frizzell under cross-examination, he showed the same thing. Bank records were pulled of Shane Austin to call his bluff to see where he was. They confirmed where he was. He said he had a satellite guy coming. That too was corroborated. Cell records put these four throughout Decatur County and Benton County, and it never put them in Swan Johnson Road's location. Zach Adams' phone, that apparently was with him all the time. At 8:19, he's receiving incoming text. 8:17 and 8:26, Miss Holly Bobo's cell phone is on a completely different tower. Facebook showed Zach online that morning. Nothing made sense, and yet these men were on trial for their life. Zach Adams' defense attorneys were told, get the ATM video by Dr. Norton. The bank said no such software existed, and TBI agents said the ATM transaction was not covered by their videos. Someone had mislabeled them to be a BP video. Thompson couldn't even open whatever it was labeled BP. And a word on an alibi. We heard delicious. They said that this ATM was baking an alibi. Well, one thing about baking an alibi, you tell law enforcement. Why didn't they tell law enforcement about the ATM? You heard Walker and Booth say, I don't remember the last time I went to an ATM. I doubt anybody in this courtroom remembers the last time they went to an ATM. They say that every time they gave law enforcement, they lied. They're on drugs. They're saying what the things they remembered of that day. The state says all of the things Zach Adams said, all of it under the influence of drugs, it was gospel. Terry Britt talking to an agent in jail was sarcasm. In the face of this, Jason Autry chooses a better option. Recreate his day with cell phone locates. He says he remembers 6 years earlier, while under the influence, somebody mowed his yard, somebody mowing their yard. Interesting that Brent Booth said, remember Autry said he remembers the guy mowing the yard. The state never once yielded any misbelief about the totality of his testimony. They told the court Autry told the world that day. You can read Jennifer Nichols' closing argument about Autry. And she says specifically, Jason sort of covers the whole morning, page 2,727 of the transcript. Sure, they got the gun wrong. Sure, Autry got the gun wrong. That could be fixed. The .357 became the .38 revolver with a .357 barrel became the murder weapon. Disregard Dinsmore vouching 6 days prior that it was a .38 revolver with a .357 interchangeable barrel, and he knows his guns. Disregard that he says, now my wife also threw out a .32 revolver. Disregard that. There has to be right objective data that the state needed. The defect was .36. The bullet casing next to it was a .380. It's excluded. Nobody pull your phone out to just see for yourself. They say, oh, Bradley Strawn sold it to Shane Austin. Disregard Bradley Strawn's testimony. That never happened. Problems again with Jason Autry. Okay, the white truck was never in the picture. That was the murder getaway vehicle. Dinsmore must have just forgotten that, quote. Let's send Booth up there to, quote, nail it down. One wonders how much testimony in this case was nailed down between Dennis Benjamin, Brent Booth, Victor Dinsmore, and the rest of the agents and witnesses. And halfway through this witness's testimony, the last witness, Mitchell Hayes, I wrote down my first question. I wonder if he knew Brent Booth. 5 minutes later, we learned they had friends and have each other's cell phone. The case went to the jury. Autry does his job. He saved his life. He gave the state what they asked for. The trial judge said it was the most persuasive and credible testimony he'd ever received. Put aside what we've heard in 2025 from General Wyrick's questions, which is all of us are presumed to think co-defendants, participants, immunity agreement witnesses, they provide self-serving and incomplete truth. That's surely not what the jury heard. Put aside Brent Booth had substantial questions about the truthfulness. Put aside Kathy Ferguson, just flat out thinks he raped her. Put aside all that. The conviction withstood the appellate scrutiny. But then one canary in the coal mine had not been forgotten about. Buried underneath 4 terabytes of discovery, everyone seemed to have forgotten it existed. And I am discussing the video of these gentlemen at the ATM. The backstory we know is Terry Dicus and Ricky Inman were going through trying to find between 8 in the morning or 7:30 in the morning and 9:40 in the morning, trying to find locations of Holly Bobo or somebody who might be driving. The records show exhibits where they were labeling, but stopping at 9:40. They had a treasure trove of this surveillance video that they dutifully labeled and then just stopped. And here's the interesting thing. So Zach Adams fills his pro se petition, and he didn't forget what he had been told. We were at the ATM. From Dr. Norton to his attorneys, the bank records show we know you're at the ATM, we just got to find it. So it's part of the post-conviction proceedings. And this is where it's interesting. Adams is talking to somebody he would not be here without, Dr. Katie Spirko. Adams, and this is recorded and listened to by Kathy Ferguson. Kathy Ferguson testified, we heard them talking about this video, the potential of it. We heard Zach say, I remember going into the ATM backwards. When I issued a subpoena to get this, the state was advised of the subpoena, they issued it too. It was limited in time, what Ms. Ferguson says, Agent Ferguson. The state was dangled the original software, and they went and got it. We'll come back to that. Months ensue. I finally filed a motion because in the January hearing on the amended complaint about this, General Boiano brings the laptop that has the still shot of the truck going backwards. The same still shot, the state also argues, shows nothing. It showed something for them to have it on their screenshot when they argued in front of you. And at that time, Zach Adams says, that's me. No one knew about it until these pleadings. No one. Agent Booth, then General Nichols, lied to you about it. They said, we remember seeing it before the trial. Cannot tell you how much I appreciate Kathy Ferguson for honoring her oath and saying Booth's mistaken, because it's not true. It makes perfect sense nobody saw it. General Hagerman says he was the expert of the 4G terabyte hard drive. The 4 terabyte drive, he was the expert. He never remembers seeing it. Terry Dicus stopped surveilling at 9:40. Agent Ferguson was the lead administrative agent. She never saw it. It was only relevant in these proceedings. Walker, who was in charge of going from the bank records to seeing if they were covered by the videos, he said, I didn't see it because I didn't look. It was mislabeled by an intern. Again, Zach's lawyers couldn't open it. What does it do? And I have belabored this. All of Frizzell's cross-examination is now consistent with Walker and Reeves. There is virtually no space between them. It shows at 10:32 when Zach is on tower 39077, and then at 10:35, 39079, he's traveling on the interstate to get to their home, to pick up the rest of his drug buddies, to get down to Parsons, and that's their day. You cannot go from where Autry says they were along this route and make it to the ATM by 11:12 a.m. We've proven that. Nothing the state can ever show rebuts what the objective science reveals. All the statements in the universe, including the guy fishing whose wife was a Facebook friend and he's buddies with Brent Booth, does not rebut what the cell records, the bank records, and the ATM video show. That's why I've spent all of my time on this dry erase board. When you understand April 13th, you understand everything. I asked Agent Booth, as an investigator, is your job to tie up independently corroborating bits of data like bank transactions and cell records to say where somebody was? Answer, I didn't do that. I don't remember that. So the court must ask itself now, how can this be? And I submit it is only for the constitutional violations that took place. Your Honor, I submit first under Dellinger, I have proven that the ATM is new. It exists the same way all other new evidence exists. It was out there in the rules of quantum physics that existed. Nobody knew it. Nobody. And the fact that Agent Booth and General Nichols were not credible validates it, because Agent Ferguson and General Hagerman, you can test their credibility, validates it's new. It proves actual innocence. If I have argued actual innocence throughout this. If the court does not find by clear and convincing evidence of actual innocence, then the court's analysis falls to whether first, standalone constitutional violations warrant a new trial, and if not standalone, ineffective assistance to counsel. This evidence is largely interwoven with each other. I suggested in opening, I'll suggest again, find your facts, and then you'll understand when you apply the law how to apply. A defense to the standalone grounds is whether it's been waived or whether it's been previously determined, such as if you have a suppression hearing, you can't argue in a PCR. The standalone, the Brady violation of Jason Autry's sentence was not revealed to the jury. The state had decided, General Hagerman, the state had decided they had virtually no case. They never communicated that to the defense. Autry, as a state agent, he was provided an immunity agreement, and he came to the court and he lied. I'll talk more about it briefly. Prosecutorial misconduct and or Brady violations. I'm just going to briefly touch on them. I'll get to them in a second. Jennifer Nichols telling the jury the 380 was excluded. No, it wasn't. That the truck had been put in the Dinsmore's garage. No, it wasn't. That the ATM video was buried in discovery that nobody knew and then mislabeled. And at this point, I think the court can see, when I asked Agent Frizzell, did anybody try to go back and look at this surveillance data? I mean, just think for a minute the millions of dollars, it's in the transcript, the millions of dollars the state had for this. But they act like it's an inmate and an appointed attorney's job to find a better, more clear version of ATM surveillance data. I think I've covered sufficiently how the ATM came to be. I want to go over some of the things the state has said in regards to it. They argue both it's nothing new, we knew they were in Parsons, who cares? And also argue perhaps a canine was driving it. They argue you can't tell if it's them. You can't tell if it's their same vehicle, although to his credit, General Hagerman says, yeah, the same hubcaps, it looks very similar, or similar. It's the exact vehicle they had impounded. And what nobody in the state has said is, if that's not them, what vehicle was Shane Austin in? Because the transcript shows they knew his vehicle was inoperable. And they knew that bank transaction took place. Dylan Adams said, that's me, the BP, standing there. Dylan Adams said, that's me in the car. Zach Adams said, that's me in the car. Jim Simmons testified, so far as we knew, there was no video. He's the one that subpoenaed the bank for the video. They both said they never saw it, and they said how important it was. Gonzalez remembers no conversation about the ATM video. Its importance was understood at trial. That this route that I have discussed about Autry's lie, if you read the trial transcript, and General Nichols, she knew when to object. Page 1,313. And remember, the testimony is the TBI agents, they ran the route themselves. They knew the route that Autry was going to testify about. The question discussing the way back. Question on line 10. So then where would you have gone after that? Answer, at some point in there it was determined where they was, and I proceeded to make my way to 30 Yellow Springs Road. How did you make your way over there? Answer, maybe through Coxburg West, comes through at Eagle Creek. General Nichols, Your Honor, at this point I'm going to object to when the witness says probably. If he doesn't know, I'm going to object to him just guessing and speculating about which way he went. She knew exactly what she was doing, as if she knew the route was impossible, because she's the one that says today or in November, we knew they were in Parsons, big deal. We'll come back to that when we discuss sanctions. The gun. It's not merely what gun was used. The gun, the .380 round next to the remains, is important because it is another bit of data that validates John Walker's map. I was more worried about this because I prepared this before Agent Frizzell testified. We are now in unison with that fourth ping added to Miss Bobo's phone. But the gun, the .380, shows the 30 minutes from Shiloh Road to Truck Tower Road is where Miss Holly Bobo was killed. Everything makes sense. There's no evidence thrown out before. The evidence is thrown out after, except most of the physical remains of Miss Bobo are by her remains. Six days before the .32 revolver was pulled out, Victor Densmore says, I'm 100%, I know my guns. It's a .38 revolver with a .357 interchangeable barrel. Jason Autry initially said it was a .357. Why did he say it was a .357? Well, Maybe he knew the Austins had a 357. Maybe it's based on discovery that a 357 had been pulled out. But when the state pulls out the .32 revolver, they don't say, maybe we're being lied to. You know what we haven't found in the 2 years of this post-conviction proceeding? The .32 revolver that Victor Dinsmore says they threw in a pond. That May 2017 recording not only revealed the gun issue. If that's not suborning perjury, I don't know what is. It's rare you see the sausage being made in an investigation where 6 years after, Brent Booth is asking Victor and Sandy Dinsmore, could it have happened? No, not happening. Brent Booth, I'm trying to get all these details nailed down so I can settle this damn case. His words. Victor says, there's no way that's happening. You never know what a jury will do. Booth says something interesting then. He says, at the time they were hiding the garage, they were cleaning the truck out to hide it. There is no scenario where that's possible on April 13th, 2011. None. Victor says, let's go with it. Let's put the truck in the garage. And the state, the prosecutors don't say, well, I'm cleaning my hands of Victor Dinsmore, I'm cleaning my hands of Agent Booth. The words were, they were unimpressed and he was leading. Jennifer Thompson knew enough to have it transcribed, but she didn't understand Rule 803.26. She didn't understand none of it's offered for the truth of the matter. She should have cross-examined them. She should have talked in opening statements. But when she tried to bring it up, shrewd as always, General Nichols objected. Can't talk about that. When we started these proceedings, Your Honor, I did not, one thing I forgot. It's interesting, there are moments where you see how Autry recreated his story. The truck in the garage is one of them. Valerie Trout's IR discussed that the Dinsmores remember a truck being hidden there. But Trout said, no, it wasn't the day of. She came here and testified. It wasn't the day of. If it was the day of, I would have put it in my report. But Autry gleaned from that, I need to put the truck hidden in the garage. When the case started, the first day I lost the motion in limine on Autry's testimony, I did not think I could prove to the court Autry lied. I didn't have his recanting. And it's interesting, the state said it's not credible because Autry was under the influence of drugs when he's talking to my agent at the Memphis jail. But now when this drug addict's talking to other drug addicts, trying to intimidate them, it's gospel. When we started the case, I don't think the state had the understanding of Dylan. Because all you have to do with Dylan, and I know the court said it's going to watch the tape, you have a transcript, I can't request enough. Absorb it. Dylan says whatever they wanted him to say. And so initially, during these proceedings, I was asking, they started off with Mark Lewis. And we get into this, what I'll refer my words as hedging. Again, to the jury in 2017 is totality. Autry's plea, Autry tells the world. Judge McGinley, most persuasive, credible testimony I've ever seen. Watch what happens in 7 months. General Wyrick is asking the first TBI agent to testify, Mark Lewis. Question, this is page 238. Is it fair to say that Jason Autry's statement that he's given to law enforcement over the years, as well as Dylan Adams' statement that he's given to law enforcement over the years, are not mirror images of one another? They're not mirror images. How many homicide statements have you participated in your career as a TBI agent? I don't know what the number is, but it would be a lot. Okay. How many of those have involved a co-defendant? A fair amount. Is it typical with co-defendants pointing the finger at one another? That's not uncommon. It's typical. Sometimes they do, sometimes they don't. Sometimes they give you a little bit, try to mitigate their own involvement. That has happened, yes. Give you just enough to let you do your work without completely, and I object. I said, Your Honor, is the state acknowledging Jason Autry's statement and testimony was false? Because that will save us a tremendous amount of effort with this line of questioning if the state is acknowledging that Jason Autry's statement was false. General Wyrick, I'm nowhere close to that, Your Honor. No, sir. Now, fast forward to Kathy Ferguson. May, August. General Wyrick asked Kathy Ferguson, of the 4, who do you think raped Holly Bobo? She said Zach Adams, Shane Austin, Dylan Adams, and Jason Autry. Oh, so you think Jason Autry raped him? Yes. All because you just listened to Dylan Adams' statement. And you realize it's a lie. Now, General Nichols says 2 things on her testimony. She said, initially, I knew it was false when I watched it. She and I agree on that totally. It's interesting, though, he got incarcerated immediately after making it. I know of no other crime where you say a lie about your involvement in a crime and you're not arrested. The problem is, when Jackson and Booth are good cop, bad copping him and saying all this, nobody had the cell phone data. To say that this is not a mirror image of Jason Autry is an offense to the mirror. Dylan has this concoction coming up over the entire night and has Autry the ringleader, has Autry throughout the day raping her, has Dylan raping her, has Zach raping her. Then, when you watch it in full, you'll get to the point when they say, and they were hiding her in a basement. It's like, oh, whoops, they're talking about a trailer. So it starts all over. And you go back to the sealed transcript of the plea deal. And you think about Dennis Benjamin and what we heard from him. February, meeting Densmore is a God thing. He's got a friend in Indiana. March, he's lying to him, saying you're going to get the death penalty. And that's who the vulnerable one lived with. I want to say this about Autry's lie. Credibility matters. I got the pattern instructions. Pattern instruction 42.04. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. By the way, the dedication to this year's pattern instruction was to Judge German. Judge Riley wrote, "Dickey abhorred anything he considered to be an injustice." But the state says, okay, in 2017 we said Jason Autry, total mourning, total testimony, total truth. Now they say, oh, you silly jury, you should have known better. You should have known that co-defendants do this. You should have known that it was a self-serving statement. You silly jury. I have custody cases all the time where you lose custody of your child if you lie. I don't say to the judge, I mean, listen, dads lie, moms lie. You know, it happens. Don't follow the law. The fact that their lead agent says Jason Autry was not truthful, but they find a friend of Brent Booth to come here and say, on a random day crappie fishing, he remembers a gunshot going off, and he remembers it echoing, and the court will listen to the exhibit. You listen to them. They're labeled how far apart they are. You listen if you hear any echoing. When he got up about halfway through, I wrote to write this question before he said anything. I wonder if he's friends with Brent Booth. Called it. We did not know, the record did not know, that Dylan, this all started with Sheila Kilzer. Kudos to Mark Lewis. He testified Sheila Kilzer wanted her son to get a deal. Kudos to Mark Lewis for explaining that. Your Honor, I think this record has been aided by what Dennis Benjamin brought to the court. The court's heard several issues regarding Sheila Kilzer, Rebecca Earp, who said the truth when she was interviewed by Valerie Trout. Again, the cell phone records have Zach and her arguing throughout late at night. And she's asked, did y'all spend the night together? And she said, I honestly don't remember. But that wasn't good enough for the state. They had to nail that detail down differently than her memory. Dinsmore, and this was something that Jennifer Thompson did not bring out. There's moments when there's these witnesses lining up, and then there's these moments when they don't know the latest thing to line up with. And so Dinsmore is saying that while these guys were there buying drugs on the afternoon of April 13th, they're talking about who's going to hit it first. And there was a while where the state believed that to be true. And then the cell records come in and like, whoops, that's not true. And Autry's painted a story with cell records. The victim's already dead. And you hear Dinsmore says, oh. Like, whoops, somebody forgot to tell him. But he still said it, and it made no sense. And Ms. Thompson did not isolate on this. John Walker, I appreciate Agent Frizzell. You know, if the record reflected at trial, the only thing he was wrong about was a road here and there, that would have been pretty different. I've thought about this. What's more accurate? The map John Walker prepared that the court did not allow in 2017, or the exhibit that Agent Frizzell prepared with consultation with the state that had the fourth ping missing that showed the direction of travel of the cell phone of Holly Bobo that morning. When Agent Walker was preparing Ms. Thompson, his testimony was it was for an hour, she did not pay attention, and she was drinking wine. the credibility of Jennifer Nichols and Brent Booth. They're the only two who said, I saw the video beforehand. Your Honor, I submit there's credible evidence that the court received then General Nichols, who testified in November, was the least credible witness this court will ever see. She objected to some of my questions from her chair, ridiculed, deflected. It was beneath the position she has held. At times when she couldn't find the right answer, she attempted to gain sympathy from the court. Interesting, she said something I'd heard from Jason Autry that said, if your records reflect that, I don't dispute that. Interesting. I wonder how that came to be. At one point, not wanting to answer the question, she said, when are we going to talk about Jennifer Thompson? I thought that's why we were here. Listen to her at the trial. Jennifer Thompson, all she had a guy who measured the .380 round in the casing. And she told the jury, he didn't know to take the bullet out of the casing. Bless his heart. As if somehow the bullet's going to get bigger than .355 when it's removed from the casing. As if the sock is bigger than the shoe. And then when you ask these people simple questions, just think about this. Simple questions. Do you know the diameter? The honest people, Agent Ferguson said, I didn't, but I've learned it. Jennifer Nichols, no. Have you Googled it? No. Brent Booth, have you looked it up? No. Just admit, we were wrong. The sanctions that the court has taken under advisement. The state is asking for the court to see that somehow that video that is in discovery either shows nothing, or if it does show something, it shows nothing new because everybody knew we were in Parsons. They said, but Katie Spirko can't go get it because it's evidence. Which is odd. From 2011 to 2024, the state did nothing to go and get the actual recorded software. Only when Katie Spirko tries to get it through a subpoena that only I have the power to get, then all of a sudden we got a problem. And you can look through the record of this transcript to see their only defense to the ATM video is it's not clear enough of a picture to see who's in it. It's almost as if the real reason they went and got what's exculpatory evidence was to make sure if there's a clear video of it, defense didn't have it first. And when I asked her whether it was important, whether she communicated to me first, that they went and got it, and they told the person who gets it, don't tell anybody, Jennifer Nichols says, who cares? It's an obligation under the rules of professional conduct when a prosecutor knows of exculpatory evidence. And you saw Jennifer Nichols' attitude. All of these things, Your Honor, combine for these standalone issues I've addressed in my pleadings. I'm now going to address ineffective assistance of counsel, and I have 12. I'll not belabor the point. Again, if I have not proven these are worthy enough on its face to survive the Rule 28, Section 5 defenses, these fall to ineffective assistance. Number one, Dylan's video. And it was odd to even watch in real time. The question was, how do you authenticate the video of Dylan's September 2014 hearing? Jennifer Thompson says, I don't know. It's pretty easy. You call one of the 3 TBI officers who were there. And it's not a confrontation issue because, first of all, it's not being asserted for the truth of the matter. And second, the defendant calls it. And look how the state, they couldn't wiggle out of it. 2, she never recreated the day of April 13th to make it sense with the objective data. 3, the gun, her question to Dinsmore was, yeah, but didn't you say it was a .38 or a .357? That's fundamentally different than you said it's a .38 revolver with a .357 interchangeable barrel. Number 4, the truck in the garage, she had the transcript. Play it at opening. Say, ladies and gentlemen, this is how the evidence has been created in this case. All of these witnesses said different things until the state said, that's enough, stop. The detail is nailed down. Jerry Gonzalez says she wasn't listening because she was constantly trying to get boxes because the state wouldn't tell them who their witnesses were. And the state during these proceedings said, no, that wasn't done. General Hageman tried his best. When we asked a couple of weeks ago to the state, who are your 6 witnesses, their response to and the court's seen it was, are we required to do this? Britt, technical difficulties regarding the wiretap. Britt admits there's listening that you're told they've probably wiretapped your home. This idea that there was not probable cause differences, Your Honor, I've gone through this. It's not the case. There's a probable cause for an administrative subpoena, investigative subpoena, that's different by statute. Everything else, the definition of probable cause is you believe somebody did it. That's it. Think how I went through point by point by point of Brent Booth, who initially said, I never said there was probable cause. And then I get the record out, and he's like, whoa. And we went through point by point. Terry Britt lied about his alibi. Terry Britt lied about his cell phone. Terry Britt's prior knowledge of Holly Bobo. Past behaviors. Thompson could not open a video. She should have gotten IT help to open it. In fairness, she did repeatedly bring up issues to the court. The transcript of the motion hearing speaks for itself. She failed to isolate the Dinsmore when Dinsmore said, yeah, those guys were talking about who's going to hit it first. And then I didn't know what they were talking about. Now I do. I feel terrible. So she said, wait a minute. But crime's already taken place and she's dead by this time. She didn't isolate how all of these witnesses, just because they say some things that sound similar to other things, it doesn't make it true when you have people who are facilitating these witnesses back and forth. She should have played the ERP video. Honestly, I don't remember. She didn't force this fundamental question of the day, which is, they just pulled off the crime of the century. They just get back to Austin's house. The records show their call was at 8:50. They now have no idea what to do with the body. So they call Jason Autry, who comes in where they drive to the river to dispose of it. They then don't dispose of it, and they drive all the way back. Put aside they drove, and you'll watch the video of Paul Dillon's route. It's nothing but woods. But they're still driving, and then at this point, even though you cannot get to this route, Thompson does not say, does it make sense now that they say, all right, we know a satellite guy's coming at Shane's house. let's just leave everything here and make our way to Sonic. That's what the proof that Autry bound them to. Put aside this issue. The remains were found with personal property. How'd the personal property get there? If they were throwing all the evidence out, wouldn't they have thrown all the evidence out? Instead, they made sure to keep some belongings together, and there's no explanation for how that could be. Because they say the truck was hidden in Dinsmore's before all of this. It's impossible. And Thompson never drove that point home. She should have told, number 11, she should have told Zach Adams, Zach, you're on trial for the death penalty. I need to let you know I have antidepressant medicine that's being upped up because of how I'm being treated in this case. You say, well, that's true, but somebody was being mean to her. Is the attorney's job to not at least tell the client, you need to know my mental health is deteriorating, which is the 12th point she should have withdrawn. I could not say it better than Forrest Richardson. He analyzed quantity, not quality. Jennifer Thompson's problem is not that she didn't know the case. She couldn't tell the jury about it because by September 2017, she'd been ridiculed. Her own co-counsel filed a motion to withdraw, saying her problem was she believed him too much. I'm curious what the state's position is. Is it that she was competent, or in the words of Jennifer Nichols, dishonest and unethical? For recording her work. Can you imagine if we didn't have the recording of Dinsmore and I was trying to tell you, Judge, I think there was perjury suborned during that day. I think Dinsmore said he didn't remember. If I didn't have a recording, they'd be like, ha, whatever, trust us. Which brings me to the third large point. When you reflect on this case, whose presentation provided you the most credible proof? Whose statements to you were true? I told you from the beginning in May, Your Honor, Katie Spirko won't be a witness. You look in the record right now to see if there was ever a subpoena issued for her today. Served on her today. I said it's for a nefarious purpose. Opening statement. Opening statement. The state said, if there's anything new that comes to this court, it's not going to be credible. I submit I have presented to the court objective scientific data that cannot be manipulated, like testimony of a fisherman 14 years earlier. The state has provided testimony from witnesses who lied about everything until their lies were nailed down to the lies of others. It was, at one point I asked a question and General Hagerman volunteered, this isn't gamesmanship. What else is it? If you don't think Jason Autry did it, then why continue to try to put him to death in pleadings? And his answer was, well, we didn't know who was going to be tried first. This is not a game. I've told you about the .32 revolver that we've never found from Dick, the second one apparently. It's been in a pond. Think about this. The state has asked you to consider the prior evidence, which is part of the record, that Zach made all these statements to drug addicts, to friends, to girlfriends he was fighting with, as somehow confessions. They have incarcerated him since March of 2014, had the ability to wiretap every single thing he's ever said, listen to every phone conversation he's ever made. They don't have the first sentence uttering a single statement that he had any knowledge of what happened to Holly Bobo or any involvement. They say that he threatened his brother. If that's the new element for first-degree murder, every parent who has children better watch out. And look at the people who supported the scientific evidence. Look what happened to them. Terry Dicus, taken off the job. John Walker, reported. Jennifer Thompson, antidepressant medicine. And Your Honor, I submit, I have shown this to you, and in this case, I have taken their witnesses and their evidence, with the exception of Paul Dillon, Alberto Davis, and Bradley Strawn. No, sorry, that's their witness. And the lawyers involved. I've taken their IRs, their agents, and shown you the truth. Your Honor, we're now time for me to tell you the fourth part of this argument and the last part of this case, which is your signature to the order. This procedure, this post-conviction procedure, Rule 28, and it's codified, reflects our country's dedication to the importance of our Constitution. Just as Marbury versus Madison said, some laws, however popularly passed, will not stand if they're unconstitutional. Neither will a jury verdict stand if it's the product of a constitutional violation. These provisions are not trivial. Due process, effective assistance of counsel. I will not lecture the court on the Constitution. I will just say this. It's what our men and women in uniform defend with their lives. Every judicial oath states you solemnly promise to support the United States and Tennessee Constitution. Each generation of Americans inherit the obligation to honor it, and if they don't, it will not stand. At times, it requires good and honorable men and women to speak up and stand up for it against powerful and popular forces. Is your signature going to be easy? Your Honor, it's not. The Constitution doesn't care if it's not easy. To put it in more practical sense, can TBI officers go around telling other witnesses to change their testimony to nail down with other testimony, and can prosecutors say, that's fine, let's use it? We'll find out with your signature. Can a prosecutor lie to the jury about a bullet size? We'll find out with your signature. Can a citizen honestly be said to have had effective assistance of counsel if the attorney was ridiculed, her first chair abandoned her, she had mental health problems, she never presented alibi evidence, she did not understand what evidence is important and how to get it admitted? We will find out with your ruling. Can the state mislabel, then lie about its existence? Evidence that either exonerates or tends to exonerate the witness, and then when they find a more clear version of this evidence exists, can they surreptitiously obtain it and tell the custodian, don't say a word about it? We'll find out with your ruling. Here's the irony, Your Honor. This ruling's not going to affect me I'm going to go back to Hickman County and divorce people. I can tell you who is waiting on your ruling. Every dishonest member of law enforcement and prosecutor that is faced with a weak case. Your green light, if you condone this, will be the best they could have ever hoped for. And to be clear, I am not saying every law enforcement or prosecutor in this case or throughout the state is either dishonest or corrupt. We live in a state that prides itself in law enforcement, and we should. Those who do their job honorably have the utmost regard for everyone in this courtroom. It is to them this court owes the duty to not reward the bad conduct that besmirches their life's work. I would read to you from page 504, retired agent Joe Walker, to be your guiding light. If there's evidence that cannot manipulate that Zach Adams was not part of this crime, you want him out of jail, don't you? If Zach Adams was in jail unnecessarily, sir, I couldn't sleep at night. I can promise you that. Is today the first time you learned that you did not look at the right video? Yes, sir. Do you feel terrible? Again, sir, I don't know. I don't feel terrible until I know for sure. You're worried, aren't you? I would hate to think that it would be, but I'm not certain at this point. No, sir. Chaucer wrote in Canterbury Tales, if the gold rust, what chance does the iron have? If Chaucer were here, he would say it this way. If this conduct in this case is not corrected in such a high visibility case, what's going to happen to the low visibility ones? Your Honor, subject to any post-trial filings as the court requires, this largely concludes my appointment to the court under Rule 28, Section 610C2, whereby I have reviewed the pro se petition, filed the amended petition asserting other claims which the petitioner was arguably entitled to, interviewed relevant witnesses, diligently investigated and presented all reasonable claims. To say that this has been disappointing and at times disgusting and even intimidated to present to the court would be an understatement. I read no such exceptions to Rule 28 that could have made this easier for me. I would be lying if I did not say I wish such exceptions existed at times. I found myself this summer working late at night often on this case and moving offices across the square in Centerville. One artifact I came across was an article in the Hickman County Times from 1981 where the then assistant prosecutor resigned because he was so upset at the corrupt, dishonest judge who presided over the court. The prosecutor not only wrote the resignation to the judge, the DA, he allowed it to be run in the Hickman County Times. The letter reviewed in detail the horrible acts from the bench this prosecutor had witnessed. And he ended it by acknowledging that this resignation made public will cause a financial cost to his future that he regrets. But he would rather his children grow up poor than to witness him stand silent in the face of such corruption and dishonor from the very institutions we cherish most in our country. The author had a daughter who has since taught history and government and a son who followed in his footsteps. For the reasons I have cited to you, Your Honor, I'm asking you to not stand silent either. Thank you.
Thank you, Mr. Bates. Ms. Lawrence, closing argument.
Yes, Your Honor.
on behalf of the state of Tennessee, on behalf of every law-abiding citizen, on behalf of every law enforcement agency in this state, and particularly those that had anything to do with this case, whether it was from the early moments of the morning of April 13, 2011, to today, we do not care where Zach Adams was at 11:12 in the morning on April 13th, 2011. The state of Tennessee could not care less where he was at that time on that day. Out of their own witnesses' mouths, Agent Terry Dicus, the operative, the key, the essential time period in this case, in this investigation, 9:39 in the morning. He elaborated a little more and said from 8 to 10:30 in the morning. That was the key time. Their own witness. This court has heard proof since May. The jury heard proof for a week. Thousands of pieces of evidence have been admitted before Your Honor, before Judge McGinley. Often when we wrap up jury cases, we say to the jury as prosecutors, particularly cases like this, it's hard to give it to you. It's hard to turn this case over to you, ladies and gentlemen of the jury. We know you've been listening. We know you've been paying attention. We chose you. We know you're going to follow the law, but it's still hard to hand that case over. Your Honor is the jury here. And the state of Tennessee has the utmost confidence that Your Honor is going to do the right thing, that Your Honor is going to follow the law that says that they have to prove beyond clear and convincing evidence, or with clear and convincing evidence, that Jennifer Thompson and Jim Simmons and Jerry Gonzalez performed below reasonable standards, not magician standards, not wizard standards, not could you maybe bribe a juror and get them to hang this thing up, but did they perform at reasonable objective standards in the moment, not looking back all these years later with hindsight, and I'd have done it differently. I'd have done this instead. Did they meet that standard? If they did, we're done. And Your Honor can proudly put your signature on that order. If they didn't, they still have to prove that it would have made a difference. That when that jury came back into this courtroom, if they'd heard everything that Your Honor has heard today, plus everything that they heard during the course of the week of that trial, that they would have come in here and said, you know what? I don't know. Or just one of them. All it takes is one to say, state didn't meet their burden. I can't sign my name on that. Would any of this have made a difference? State submits that the only difference what has transpired in this courtroom since May and outside of this courtroom in an attempt to manipulate these findings in an attempt to manipulate and threaten witnesses, that the only thing that has changed standing here today, December 29th, 2025, is we know even more certainly how guilty he is. When we started these proceedings in May, the state pointed out that he, the defendant, sits before you, a convicted murderer in the state of Tennessee. And it's louder today than it was when we started in May. Because what the petitioner is asking the court to do is to look at the proof through a straw. Please don't read all of Mike Frizzell's report. Let me just scream and carry on about how the state hid evidence. If it wasn't so tragic to sit here with the Bobos in 2025 and watch them go through this, it's comical to carry to its ultimate conclusion what the petitioner is asking the court to believe. Please don't look at all of Mr. Frizzell's report. Just focus on the fact that he put that fourth ping on a later page. At no time did Mike Frizzell today or ever in front of that jury say, just look at this little piece of what I found. Look at all of it. Everyone who testified in this courtroom before Your Honor and who testified before that jury, with the exception of a few that I will talk about, everybody, from law enforcement, look at all of it. You got it all. Here it is. I would hazard to guess that never in the state of Tennessee, perhaps in any state, I don't know, but in the state of Tennessee, never has a trial been conducted where the defense team had everything the state had. Everything. So this same petitioner who wants the court to believe that we're over here manipulating witnesses and telling people what to say and hiding stuff in our bags, I don't know, they had it all. They had it all. And we were at their mercy to receive the information. We were at their mercy to receive the information that Jennifer Thompson decided to trickle in bit by bit. To stand before this court and accuse in the way that petitioner has done is offensive to not only the men and women that have worked this case, but everybody that's out there right now. Because to sign this imaginary order that the petitioner is asking the court to sign, you would by doing so say, it's okay to come into court and make up stuff. It's okay to come into court and have selective amnesia about things. This same defense attorney who put in 3,000 hours on this case shut down her whole practice. And we only know what we know from the time she was appointed. She was hired by the family for a year prior to that. So we'll never know the grand total of hours that she put into this case. It was an obsession. She put makeup on him every day. She dressed him in her husband's suits. They got along famously. They talked, they communicated, they met. The little that he would talk. And in the thousands and thousands of hours that Jennifer Thompson put into this case, she still believes he's innocent. That's clear by the fact that she came in here and testified the way she did. It is absolutely unbelievable, not plausible, not credible. I don't really remember what he told me about where he was that morning. That was her answer to my question. Well, you had conversations with him. Yes, of course. You met with him many times. Of course. You talk to all these people, yes, of course. Well, okay, we're all dying to know. Because I can tell the court this as well on behalf of the state of Tennessee and on behalf of every law enforcement agent across this beautiful state, that if an innocent person is sitting in prison, we want to get into action as quickly as we can. Please, by all means, show us, tell us, point it out. He can't. He can't. He hasn't. And he never will. Perhaps the truth, if he's been paying attention, is a little bit clearer to him now than it was during the trial. The proof that this court heard, the proof that the jury heard, was that this defendant was with Jason Autry the morning of April 13th, 2011. No one from the state of Tennessee has ever presented a theory in which this defendant is the one who grabbed Holly Bobo from her carport. I would submit that that's never been a theory that's been argued, articulated. He was calling the shots. You see, none of this was supposed to go down the way it did. We'll never know, for whatever reason, what motivated them that early morning to grab Holly Bobo. We'll never know. It'd be great if there was a turn of conscience, like Jason Autry and Dylan Adams had, of just giving us a little bit, but you got to go to hell to catch a devil. And that's where we've been for a long, long time. Holly Bobo was not supposed to fight as hard as she did. Holly Bobo wasn't supposed to fight for her life. Dylan Adams was never supposed to talk. The proof, it was heart-wrenching to watch. And if, again, the petitioner's petition is that Jennifer Thompson should have put Dylan Adams on the stand for the jury to hear, perhaps the only thing that would have come from that lame move was that the jury would have been out and been back with their verdict a lot faster. Jennifer Thompson managed to keep that jury out for 2 days. If the jury had seen the manipulation and the fear of Dylan Adams, that's what this is all about. Of course Dylan Adams is going to do what I tell him to do. Get rid of the phone, get rid of her stuff. Jason and I are going to go get rid of her body. You all get rid of this junk, and we'll meet up here later. And we know all this from the cell phone records. We know all this from the towers. The court has the proof, and the state has great confidence that the court can see through the smoke and mirrors, the emperor is wearing no clothes case that the petitioner has put on. The only thing that would have happened had Dylan Adams testified was a faster verdict. The only thing that would have happened had the defendant testified in his own behalf was a faster verdict. She kept that jury out for 2 days, and she kept him off death row. One of the most heinous, complex, violent, indefensible cases in this state's history. Absolutely no motive other than bragging rights. That's it. If I pull this off, stories I'll get to tell. Holly wasn't supposed to fight that hard. And gosh, she wasn't supposed to be alive at the river. The court will recall they drove to the river, an area that this petitioner was familiar with, testified to it finally in 2025, probably never told his lawyer he'd been down there before despite the graffiti and the countless times he'd been down there fishing and doing what else. They took her down there to gut her body. Because that's going to float, or not float rather, that's going to sink. And then we're out of here. We're out of here. We'll drive into town. I gotta get Jason back to the church at Yellow Springs because Jason Autry's gotta make sure that his girlfriend sees him at lunchtime or she's gonna be hopping mad. I gotta drop Jason off at the Yellow Springs church. I'm gonna pick up Shane and Dylan because those two knuckleheads I gotta keep an eye on. They ain't the brightest, and I don't want them talking. And we gotta all be in this together. All for one, one for all. And we'll get into town, and we'll be seen. This will be great. And think of the bragging I'll have. Holly Bobo. The big prize. So they get down to the river, and she's still alive. This is not going as planned. Thank goodness. We've always got a gun. A bullet to the back of the head. If the court wants to disregard Mitchell Hayes' testimony, of course the court has that purview and power. Just like the jury had the purview and the power and the responsibility, and they took the oath to judge every witness's credibility to testify. And let's not lose sight of the fact that Jennifer Thompson put on quite a defense. We've all participated in criminal prosecutions where there's nothing done on the other side. An objection here or there, cross-examination here or there. That's it. Jennifer Thompson is a fighter. She was dogged and relentless and focused on one thing and one thing only. Walk him out of the courtroom. She's still proud of her work on this case. It's one of 3 featured cases on her website. If she was so distraught about her performance and her participation in the denial of his constitutional rights, why didn't she report herself? Why didn't Jim Simmons report her? Why didn't Jerry Gonzalez report her? From the river, they go back 100 miles an hour with some of what's come out of his mouth in terms of the distance they're traveling. They've got a dead body in the back of the truck. The body was supposed to be in the Tennessee River, but we couldn't do that because she was still alive. We had to shoot her, and we heard a boat. Your Honor, met that boat driver today. The state submits to you one of the most credible witnesses to ever take the stand in this beautiful courthouse or any other across the state. Here's what I heard. We do not know, sitting here today, where the defendant was from 7:50 in the morning until they land in Parsons and his phone starts pinging around 11:12, 11:15. Except we do know a little bit about what he was up to. The problem is he can't be honest about it, because to be honest about it would be to admit once and for all as Jason and Dylan have done, his role in this. But he is praying and hoping against everything he has left, against the power of the podcast and some veiled, I don't know, threat to the court about ignoring the facts and ignoring the law, that the truth will be buried in the same way he was instructing Mr. Bates' agent, Ms. Spirko, to bury something on a piece of property. Here's where you go. Here's what you do. Don't take a phone. They might track you. He can't own up to what he's done because it's too horrible. And this game is too far gone. But we know from all of the cell phone evidence, from Jonathan Reeves, who Mike Frizzell said it today, he said it during trial, I agree with him. Jonathan Reeves and I see eye to eye on this thing. The only one that Mike Frizzell takes issue with is Johnny Walker, because he said there's no empirical data to support the limb that Johnny Walker got out on. And I would remind the court that petitioner's own witness called Johnny Walker incompetent. Jerry Gonzalez smirked at the skill set and the level of incompetence of Johnny Walker when he was on the stand. The same Johnny Walker that when, in his mind, he manages to crack this case, he marches into that jail and gets Terry Britt to confess to kidnapping and murdering Holly Bobo. What does he do with it? He sends an email to himself and closes his computer down and goes home for the weekend. Even he knew it was worthless. Even he knew he was being played. This same petitioner who's asking the court to free a convicted, guilty murderer wants the court to order the charges against an innocent man. Much of the petitioner's early documents and position in this case is that we got the wrong person. Terry Britt is who did this crime. Terry Britt killed Holly Bobo. There is zero proof of that. Out of Terry Dykes' own mouth, the only proof he had was that Terry Britt is a registered sex offender. We'll all agree to that. He's got a revoked license and he lives near the area. Is that really the society that we want to live in? Is that really the criminal justice system that we want to proudly be a part of? To ignore the mountain of evidence against the convicted murderer and lock up the innocent guy. Because this just didn't turn out the way it was supposed to. Holly wasn't supposed to fight so hard. Jason Autry was not supposed to testify. Dylan Adams was not supposed to talk. And just one person on that juror, just one person on that juror needed to not be convinced by the highest standard in jurisprudence, beyond a reasonable doubt and to a moral certainty. I want to make sure I get these times right, because there's been a lot of attempts to, again, look through a straw and not look at everything. Terry Dykes, 8 o'clock to 10:30 is the relevant time. 11:15 to 12:15 is not relevant. He said it. Everybody said it. The state will say it again. We could not care less where this defendant, where Shane Austin, where that alleged Silverado, where Dylan Adams, couldn't care less where they were. At 11:15 in the morning, on April 13th, 2011. What the state does care about is where they were from 8 to 10:30. And what we know about the phone information, from 9:12 in the morning to 9:50 in the morning, 9:12 in the morning to 9:50 in the morning, Zach Adams is inactive on his phone. There's no activity going on his phone. 8:55 to 9:42, Jason Autry's phone is inactive. They'd been talking before together. Their phones had been active before as they're making the plan. Hey, this has all gone amok down here. I need your help. We got Holly Bobo, and this is going to be fun. But during that vital time period, out of every law enforcement officer that took this stand, regardless of who called them to the stand, that's our key point. Total inactivity. 9:50 to 12:18 p.m., 9:50 in the morning, on the tower, closest to the river, Birdsong, back toward the truck stop tower, and on into Parsons, this defendant is wearing those keys out. There are 25 communication activities between 9:50 in the morning and 10:30 in the morning from this defendant's phone. He is frantic, absolutely frantic, because she wasn't supposed to be alive at the river. The state wishes, for purposes of this presentation, but to be quite honest, Your Honor, more importantly for the Bobo family, the state wishes we could tell you when they dumped Holly Bobo's body. We know where it was found. Again, through the straw that the petitioner is holding and asking the court to look at the evidence through, there was a .380 casing, not bullet, despite their repeated attempts to use that word bullet, casing, found near her body. Well, guess what? There were also about 100 other items found near her body, all of which were collected. Laura Hodge with the Tennessee Bureau of Investigation took the stand and testified at trial, and there were 82 items put into evidence alone while she was on the stand. That's how much stuff there was out in the area where Holly Bobo spent her last moments on earth. Lots of other ammunition was found out there and a myriad of other things. It doesn't matter. We still don't know when the body was put there. It's pretty clear from the cell phone testimony and from what Your Honor has seen in the beaten down testimony of Dylan Adams. And again, it was hard to watch. As a human being, it was hard to watch him on the stand. I think we all probably caught ourselves having to remember the role that he played in this rape, kidnapping, and murder of an innocent young girl. But if you didn't believe before he took the stand that he had spent his whole life being physically, emotionally, and psychologically abused and beaten by the petitioner, it was pretty clear. The same petitioner that shot his mother, the same mother who the court heard on the jail calls, threatening him, yelling at him, to the point that he cried in the jail calls, and he cried here. 14 years later. The same frantic murderer who's wearing his phone out from 9:50 to 10:30 in the morning. He's calling Rebecca Earp. He's calling Dick Adams. He's calling Joe's video. He's calling everybody he can think of, because now he's got a truck with a dead body in the back, and he's got some work to do. Where can I go and safely take this truck? Is my grandfather home? That's why he's calling Dick Adams. Will Rebecca Earp lie for me and be my alibi? No, she wasn't going to do that. And the jury heard all of the attempts of an alibi that this petitioner made, both in the days and weeks and months after Holly Bobo's murder. And I will not belabor them, but they were all blown to bits. Jason Autry, first time he was contacted by law enforcement, came up with some story, but I was working, gave them the name of the guy he was working for, exactly where it was. Law enforcement, I know, ran it to the ground, as they do, as they are emboldened and empowered and expected to do. Ran it to the ground, and that man said, I hadn't seen Jason Autry since I don't know when. Their alibis were falling apart, but the lead officer was ignoring it because he was looking through a straw. The same straw that the petitioner is asking the court to use. He's wearing that phone out, trying to figure out where he's going to go and get rid of this body, get rid of the white truck, the same white truck that jurors heard witnesses testify had been driving down the Bobo's street in the days leading up to Holly's abduction. White truck, I got to get rid of it. The black truck was probably the one used to drive around and get rid of the evidence. We'll never know. We'll never know the order of things, and we will never, ever, ever, ever know unless he has a moment of weakness when Holly Bobo and her phone were separated. No one took this stand with any credible proof to say, I saw it. And that's all we have, is speculation and theory. But every expert that is truly an expert, that truly has credible experience in this line of work, said there's no way to tell. There's no way to tell from this data when she was separated from that phone. He's frantically trying to figure out where everybody is so he can get his story straight. And in that same day, or in the days that follow, well, let me back up, I'm sorry. Later that night, this same frantic petitioner is trying to steal cars and guns from his grandfather. And the court heard those 911 tapes. They're on a first-name basis with the Adams household. The same Dick Adams who, when asked if Zach had anything to do with the murder and rape and abduction of Holly Bobo, said, if he did, he's probably good for it. Imagine that being your grandfather's response if you were accused of one of the most heinous crimes to have occurred in West Tennessee in modern time. Yeah, it does not shock me that Zach might have had something to do with this. Because that very night, Dick Adams came face to face with the frantic murderer. And nobody but family, nobody knows better than family what he's capable of. He's out of control, trying to get out of town because he's worried that it was sloppy. It did not go the way it was supposed to go. The court heard endless testimony, as did the jury, of all of the bragging. And the only really reasonable question to ask there is, why would you say those things if they weren't true? Why in the world? What is the motive? There's been absolutely no credible proof about those statements, about misunderstanding of those statements. You half expected for somebody to come in and say, oh, we were all in the same room together when he said it. These people are scattered all over the state, in various places, coming in contact with him at different times. No body, no gun. Before the body and her skull with the bullet to the back was ever found. The bizarre, frantic behavior of washing the mattress and the officers that testified to that, those were not the scratches of a meth addict. And if they were, why lie about it? If they were, why lie about it? Because he can't face the truth. It's too ugly. The first time anything about a bank is mentioned is in September of 2014. This defendant and his meth monkey team, the A-team, whatever they like to call themselves, had been talked to who knows how many times by law enforcement as they combed this area, looking for Holly, looking for anything, anybody who knew something, saw something. Never did any of them mention, until it was Shane Austin's parents in September of 2014 that said, I don't know, maybe there was a bank transaction? Okay, thanks. Your Honor's seen the still. Your Honor's seen the video. More importantly, the court has heard from everyone who has taken the stand, with the exception of the convicted murderer and his beaten down brother, Dylan Adams, that it's not worth the paper it's printed on. It shows nothing. The emperor is wearing no clothes. The murderer has no defense. Even Jennifer Thompson, who we'll never know why, what motivated her to take the stand and answer the questions in the way she did. Even she looked at it and said, I don't know what this is. No, I can't see anybody in there. Of all of the people on the planet who would have loved to have proven us all wrong, to have gotten one up on Judge Nichols, I mean, the court's heard ad nauseum about their lack of a friendship. Who would love anything more than to be able to say, you all are so dumb, here it is right here. But even she couldn't do it. The only two that see anything in there are the one that's doing life and the one that was told what to say. Every other witness, whether petitioner called them or whether we called them, I don't know what that is. It's got no value. But even for the sake of Your Honor's responsibility and the incredible job in front of this court, let's just say, for the sake of this argument, that it is clear as day that you can see the A-team in the front of that truck, pulled in backward at the bank, at 11:12 in the morning. Who cares? Holly's already dead. If that video had been taken between, let me make sure I get the times right from Agent Dykus, between 8 and 10:30, and you could see anything, yeah, that's a pretty good alibi. But the time is irrelevant. The state couldn't care less, nor does the law care, where this convicted murderer was after he'd already killed Holly Bobo. And all that the court heard in terms of alibi from Dylan Adams and this defendant was where they were after they killed her. Don't look too closely at what the proof shows as to where we were while she was being kidnapped, raped, and shot in the back of the head at the Tennessee River. Don't look too closely. Jennifer Thompson whether she looked at the video or not, she did spend time before going to law school as a computer programmer. And I think the court can see from the evidence that was admitted, the tech-savvy ability that she had. She knew what she was doing. She was an experienced attorney at the time the family hired her. She served then, she serves today on the CJA panel. Every accolade that you can have thrown at you as an attorney has been thrown at her. This one just didn't turn out the way she wanted. Whether she saw it or not, it doesn't matter. Because she had a strategy. And she had the best defense that has ever been handed to a defendant in the history of the state. And his name was Terry Britt. He looks and walks and talks like and is a registered sex offender. And it only takes one to not listen to all of the evidence and all of the facts and all of the law. That was her strategy. Imagine if this were all reversed and she had put the defendant on the stand and he had done a bang-up job at trial just like he did before the court with his selective amnesia. Oh, I don't remember where I was. Oh, I don't know where I was. No, I didn't say that. That was just a joke. Imagine if she put him on the stand and he had testified and that jury went back and convicted him. Then the accusations from this side would be, you should have blamed Terry Britt. You've got this walking poster child. Every defendant accused going forward is going to point at him. Why didn't you put on Terry Britt? Why would you ever put on proof putting these guys together? That's why the video is useless. Even if it showed anything, even if the time helped, why would she want to put them together? Her defense was to distance him from the others, the A-team, and to pin this on Terry Britt. But in addition, she didn't just sit back on her laurels with that as her sole objective. She cross-examined the fire out of just about everybody that took the stand. Can we sit here in 2025 with hindsight and say, oh, but you should have asked it this way? Sure, we can do that all day long. Thankfully, that's not what the law requires. The mandates of the law are for the court to look at the totality of the case at the time. And at the time and in the moment, and given what Jennifer Thompson and her team of 24 people that were working day in and day out around the clock while this case was in trial, their strategy was golden, easy, succinct, easy to understand. Very rarely does a defense attorney have a name to put on the some other dude did it defense. this jury got to meet him and size him up and listen to her cross-examination and take it all into account and weigh it all. The state has great confidence and faith in this court. And just as much confidence and faith in our system. A system that provided this convicted murderer with every piece of evidence that the state gathered to prove his guilt. A system that allowed his team of lawyers and experts and jury consultants and forensic experts, and I mean the list is as long as this aisle. A system that never said, no, that's too much money. We're not going to pay for it. Everything that Jennifer Thompson requested was granted. A system that selects from the community men and women, not lawyers, to second judge and second guess. Men and women of a community to listen to the law, to listen to the facts, and to never, ever, ever leave their common sense behind. A system that instructs that jury of their incredible responsibility that you must, every one of you, all 12 of you, find beyond a reasonable doubt that Zach Adams raped, kidnapped, and murdered Holly Bobo. A system that made everything available to him. Ms. Thompson was hired by his family and then convinced the court to appoint her. She kept him off death row. And a system that allows Your Honor to look at everything, what the jury heard, with the added benefit of what the court has heard now. And the absolute, unbelievable testimony that she just doesn't recall what he said, or that all of those communications with her client, every note she took, is missing. It's not plausible. The focus group that we asked her about, for a minute there I thought, well, geez, did we read something wrong? And she had zero memory of that. And the court saw from the bar graph this morning from Forrest Richardson, 40 hours spent on a focus group. Dogged, relentless, obsessed. Zach Adams was afforded one of the greatest defenses and defense presentations and defense teamwork of any accused criminal in this state. To the tune of $275,000 for Ms. Thompson alone, just during the time that she was appointed. The standard that the law requires is light years beneath what she gave him. And even her dogged, relentless, obsessed attention to detail, quest to win, desire to beat Jennifer Nichols, none of it mattered. Because in the great state of Tennessee, in these courtrooms, the law is the boss. The law that that jury followed and proudly walked back in here and returned their verdict to Judge McGinley, and the same law that Your Honor will follow. Same law regarding credibility of witnesses, reasonableness, prejudice. Would any of it have made a difference? The state submits the only difference is that verdict would have been a lot faster.
Thank you, Ms. Wyrick.